March 1989, Shirley Gibbs Russell went missing from her officers' quarters in Quantico, Virginia. She was a captain in the U.S. Marine Corps. She has never been seen since. A 26-step plan to commit the perfect murder would point officers in the direction of Shirley's killer. This would be the first case in U.S. history where a person was convicted in a federal court of first-degree murder without a body, a crime scene, or a weapon. Hey everybody, and welcome to episode 22 of the Student's Verdict podcast. Thank you for joining me on another true crime adventure. To all of you new listeners, welcome. Pull up a chair. My name is Emily and I'm your host. If you haven't already, please go and listen to some of our earlier episodes, including the deadly drug trial, the kidnapping of Marita Veron, and Larissa Schuster, the acid lady. Please follow me on all the socials. That's Instagram at the Student Verdict Pod, Twitter at Student Verdict, and on Facebook, where I have a page and a group for us to chat and share. If you missed anything I just said, links are in the show notes. As always, if you enjoy the show, please consider leaving me a review. If you don't like the show, then please keep your opinions to yourself. As always, resources used in this episode will also be linked in the show notes. In the show notes, you'll find links to the Student's Verdict merchandise and my Patreon page. Any support you'd like to give is hugely appreciated. With all of that said, let's jump into today's episode. Shirley Gibbs met her future husband, Robert Peter Russell, while the two were stationed at Parris Island Marine Corps Base in South Carolina. During this time, Robert was a Marine Corps captain and was married to his first wife, Pamela. The couple was divorced in April 1987, and 3 months later, Robert was transferred to Gulfport Naval Base in Mississippi. While stationed here, he continued his relationship with Shirley. It was also said he became romantically involved with a number of other women at the same time. 2 months after Robert arrived in Gulfport, he and Shirley were married. Unfortunately, their marriage was not a happy one. It was reported that there was abuse in the marriage. According to witnesses, Robert would often use racial slurs against his wife, and often worried what his Marine friends would think when they found out who he was married to. As well as abuse, there were the extramarital affairs. Shirley consulted marriage counsellors on at least 8 different occasions during her short marriage to Robert. In July 1988, the couple was transferred to the Quantico Marine Base in Virginia. Shirley and Robert were both officers in the Marine Corps. But where Robert was just getting by in his job, Shirley excelled. Where she was seen as a good candidate for the rank of major, her husband, in contrast, was discharged from the Marine Corps just 2 months after arriving at Quantico. He was discharged under other than honourable conditions because of unauthorised periods of absence, unauthorised use of government telephones, and fraudulent claims against the government. At the time, Robert's discharge became effective. He and Shirley were living in Quantico. Following his discharge, Robert took a job as a special education instructor at a local high school, and soon thereafter began a romantic relationship with a woman by the name of Sandy Flint, a colleague of his at the school. During moments of intoxication, it was said he bragged to friends about his affairs, while in his sober moments, he was plagued by his own insecurities, which led him to planting surveillance devices in his wife's car and keeping a close eye on her every move. As you can probably imagine, all of this added strain to an already struggling marriage. Unsurprisingly, Robert and Shirley eventually decided to go their separate ways after only a year of marriage. Following their separation, the couple sought separate accommodation, and on the 28th of February 1989, Shirley moved into the bachelor officers' quarters at Quantico. Robert moved into Sandy Flint's Dale City residence on the 2nd of March 1989. Because Robert and Shirley had vacated their married officers' quarters, the quarters had to be inspected. So, the couple arranged to meet at their old quarters on the morning of Saturday, the 4th of March, in order to prepare for the inspection, which was scheduled for Monday the 6th. Shirley had asked her sister, Doretha Sogren, to drive up from Virginia Beach to be with her while she was preparing to move out of the quarters. She may have wanted her sister because of the move, or it may have been because her separation would soon be finalized, as Shirley had picked up the final marriage settlement the day before. Unfortunately, her sister was unable to make the trip, as Doretha's employer had asked her to work that Saturday morning. Saturday, the 4th of March, was a cold and rainy day. Just before 9 a.m., something strange happened. Doretha, Shirley's sister, received a telephone call from her soon-to-be ex-brother-in-law, although he identified himself as Lieutenant Colonel Hodges, who was Shirley's commanding officer. Robert asked Doretha if she knew where her sister was. Doretha was not stupid and immediately recognized Robert's voice and said, "Bob, I know this is you. Why are you playing games with me? You should know where Shirley is because you were right there in Quantico with her." Later that morning, at around 11 a.m., Robert left Sandy Flint's residence after telling her he was going to meet Shirley at their old married quarters. Rhonda McCumber, who lived in the quarters adjacent to the Russells, testified that she saw Shirley outside their quarters at about noon that day. Shirley had planned to have lunch with Captain Patrice Gale after her meeting with Robert, and had agreed to meet Gale at Shirley's bachelor quarters. So, at approximately 1:20 p.m., Gale made her way to meet Shirley. When she discovered that Shirley wasn't at her bachelor quarters, she drove over to the Russells' old married quarters. When she arrived, Robert told her that Shirley had walked to the Marine Corps Exchange to purchase paint. Gale would later testify that Robert was flushed and sweating profusely. After Gale left the Russells' old married quarters, Chief Warrant Officer Kenneth Shilko invited Robert into his quarters, where the two men talked and drank coffee for more than an hour. Shilko would later testify that he did most of the talking, and that Robert seemed distracted as he kept concentrating on a clock that hung on the wall in Shilko's quarters. After the visit, Robert returned to Sandy Flint's residence and showered. By this time, it was approximately 3 p.m. After showering, Russell called his parents in St. Clair, Pennsylvania, and asked about the weather. Shortly before 5 p.m., Robert left Quantico and headed to his parents' home. Although he owned an open-bed pickup truck, instead of taking that, he drove Sandy's car, which was a blue, 4-door Mercury Tracer station wagon. The neighbor, Rhonda McCumber, testified that she saw a small, blue station wagon backed into a parking space near the door of the storage shed adjacent to the Russells' old quarters at approximately 5 p.m. Sometime between 9:30 and 11 p.m., Robert again called Doretha and again asked whether she knew of Shirley's whereabouts. Again, she told Robert he should know where Shirley is. Robert told Doretha he had not seen Shirley since she left for the Marine Corps Exchange. He then said, quote, "You know, me and Shirley got really close this weekend." Doretha was having none of it, though, and said, quote, "Right, I know better than that because I know that Shirley wasn't going to get back with you." Robert then said, quote, "You know, Shirley is really at peace with herself." After this comment, Doretha terminated the call. It's reported that Sandy Flint didn't see Robert again until the morning of Monday the 6th of March. When Robert returned Sandy's car, she noticed that it had been cleaned, but not just cleaned, it had also been waxed and vacuumed and had a deodorizer hanging from the rearview mirror. Sandy would later testify that although Robert had borrowed her car in the past, this was the first time he had had the car cleaned before returning it. That same morning, Robert asked Sandy's father-in-law, Robert Flint Sr., how he could remove bloodstains from concrete. Robert Flint, a civilian painter at the Quantico base, told Robert he should try cleaning the concrete with muriatic acid. Before we get any further into this story, I'd like to just pause a second to introduce you to some friends of mine who have a great podcast called Twisted and Uncorked. This is one you won't want to miss out on.
Hello, Twisted Humans. This is the podcast where two best friends chat true crime and have a glass
or two
of wine. I'm Alicia.
And I'm Caitlin.
And this is Twisted and Uncorked.
So join us every week for Casual Tuesdays, where we release a new episode. We are now available on all platforms, including Spotify, Apple Podcasts, and Google Play. Rate, review, and subscribe.
Cheers!
Cheers!
That same Monday, Shirley failed to show up for duty, and she missed an appointment with a Navy chaplain who had promised to help her with her income taxes. No one had heard from Shirley since the 4th of March. Her driving license and passport were also missing. Her credit card, savings, and checking accounts had all been inactive, and the property she had placed in storage remained untouched. Shirley Gibbs was reported missing on the 7th of March after failing to report to Marine Corps Combat Development Command. Any time a Marine fails to report for work within 48 hours, it's assumed that he or she is AWOL. However, since Shirley was known for her promptness and strong work ethic, her absence was regarded as suspicious. After the Naval Investigative Service failed to locate Shirley, the matter was turned over to Special Agent Wayne Gilbert of the Philadelphia FBI office. On the 8th of May, 1989, Jane and Barry Zimmerman had just returned from Pottsville to their 52-acre cattle farm when they were shocked to find it crawling with dozens of FBI agents who were meticulously searching the property while black helicopters hovered over the farm at a low altitude. The FBI agents occupied the property for over a week, using bloodhounds, metal detectors, and infrared cameras. It wasn't until the search was completed that the Zimmermans realized that they had been looking for the missing wife of a disgraced ex-Marine. The search, which covered more than 2,000 acres between Mahanoy City and St. Clair, and involved 8 helicopters and more than 100 agents, was described as a high-priority assignment. A second search took place on the 28th of August, this time focused on the mine-stripping area west of the Burma Road, near the German Protestant Cemetery in Mahanoy Township. Once again, this investigation drew upon the resources of multiple local law enforcement agencies and included the State Police K-9 unit. Several amateur sleuths and treasure hunters would also join the search, armed with metal detectors. There was a buzz at one point during the investigation when officers found part of a blue velour sweatshirt on a coal bank. It was reported that Shirley had been wearing a similar blue sweatsuit when she was last seen. The item was turned over to the FBI for analysis, but would later prove not to be a match. As agents conducted their search, Robert was staying at his parents' home in St. Clair. When agents arrived at his parents' door, Robert seemed to be baffled by his wife's disappearance, claiming that he finds out what's going on through the newspaper and the TV. He said that he was going to give state and federal authorities his full cooperation and told reporters that he believed his wife was still alive, saying, quote, "Just like other couples, we've had our ups and downs, but I love her dearly," adding that he had voluntarily submitted to a polygraph examination. Robert was interviewed by police on a number of occasions, but it wasn't until February 1991 that the FBI went in for the kill. By this time, Robert was working as a counselor at Graterford State Correctional Institution in Montgomery County. It was during the morning of the 8th of February that the FBI arrested Robert while he was at work. The day before, a federal grand jury in Alexandria, Virginia, had indicted him with the murder of his missing estranged wife. After his arrest, Robert was transported to the Allentown Eastern District Court. After the hearing, he was taken to a detention cell in Philadelphia to await extradition to Virginia for his arraignment, when the charges would formally be put to him in court. Robert was later released into the custody of his parents in St. Clair after they posted $50,000 bail. FBI spokesperson Linda Vizzi made a statement to reporters saying, quote, "It's a unique case for the government because we have no body. Through the indictment and ongoing investigation, we hope to eventually recover a body." The prosecution's evidence was entirely circumstantial. The only thing the prosecution had to work with was a motive and a damning computer document. Since grand jury testimony is not a matter of public record, the media had no idea until the murder trial that this piece of evidence had been in the FBI's possession for 2 years. When Robert was being interviewed, he didn't know that the FBI, when cleaning out his office in Quantico, had found what they believed to be the smoking gun in this case: a computer disk containing step-by-step instructions on how to commit the perfect murder. Of course, Robert's attorneys vigorously attempted to have this computer file stricken from the prosecution's list of evidence on the grounds that it had been obtained illegally. They also argued it had no bearing on the case since it had been created prior to Shirley's disappearance. Frederick Fanelli, the attorney heading up Robert's defense team, explained, quote, "This list they refer to was 14 or 15 months old before Shirley disappeared." Despite their protests, the list was entered into evidence, and the trial was scheduled to begin on Tuesday, the 23rd of April, 1991. The defense immediately filed a motion claiming that the federal government had refused to disclose evidence that could help Robert's case. Fanelli cited 8 incidents in which federal prosecutors had failed to provide the defense with notes, documents, and witness statements that could potentially establish an alibi. The motion was dismissed. Jury selection began a few days later. On the 3rd of May, the third day of jury deliberations, Robert's defense team filed another motion, this time seeking a mistrial after they learned that 5 FBI agents had secretly raided their client's house in Mahanoy City the previous day. The motion was dismissed by U.S. District Court Justice James C. Katcharis, who would be presiding over the case. When asked about the actions of the FBI, lead prosecutor and Assistant U.S. Attorney Lawrence Lyser stated he didn't think it was unusual. The defense contended that the FBI's search was just further evidence of how weak the government's case was. The prosecution presented the jury with their opening argument, during which they stated that it was their contention that Robert Russell had shot Shirley Gibbs in the back of the head with a .25 caliber handgun while she was standing in a storage shed connected to their old Quantico apartment. They alleged that Robert then drove Shirley's vehicle, a station wagon, to Pennsylvania and dumped her remains somewhere between St. Clair and Mahanoy City. The prosecution would introduce the computer disk. On the disk was a file named Murder, and in that file was where they found what appeared to be a 26-step guide to carrying out a murder. Can I just make the point that if anyone ever looked at my computer, the stuff that I've Googled when researching cases, I would be in serious trouble. That's for sure. But anyway, the prosecution also introduced a handgun and ammunition that was similar to the one that Robert had admittedly purchased the day before Shirley disappeared. I'd like to reiterate here that this was not the gun, but was similar to the gun they believed had been used. The prosecution called a number of witnesses that would incriminate the defendant Robert Russell. Sandy Flint, Robert's girlfriend, testified that Robert once told her that she should not be surprised if, quote, 6 months down the road, you hear that Shirley is dead because I'm going to kill her, and that Robert once showed her a homemade silencer. At least that was what he called it. Flint testified that Robert told her that if Shirley was ever found dead and someone asked her about the death, she should say she didn't know anything about it and she shouldn't remember this conversation. Robert's brother, Ronald T. Russell, testified that late one cold February night, Robert called him to make an unusual request. According to Ronald, his brother asked for dynamite. When Ronald asked why, Robert answered, to blow her up. Thomas J. Maris, a Marine Corps lieutenant and a neighbor of the Russells at the Quantico base, testified that after an argument with Shirley, Robert removed a pistol from a drawer, stating, I got something for that, referring to Shirley. John Seasock, a drug and alcohol treatment specialist and an acquaintance of Robert's, testified that he and Robert once had a discussion about the most effective way to commit suicide. During the course of the conversation, Robert suggested that shooting oneself, either in the mouth or behind the ear, would be the most effective method, and that the best way to kill someone was to shoot them behind the ear. Robert's first wife, Pamela, testified that on one occasion in 1981, Robert had told her that there might be bodies hidden in the mine shafts in St. Clair, Pennsylvania, and that, quote, if he wanted to get rid of her, nobody would ever see her again. John Keevil, a Marine Corps MP and an acquaintance of Robert's, testified that more than a year after Shirley's disappearance, Robert asked him how long it took for a body to decompose. The prosecution introduced forensic evidence. Expert witnesses testified that a .25 caliber pistol of the type that Robert purchased could have been fired in his quarters without recognition by anyone nearby, and that a close-range shot behind the ear from that weapon would probably not produce an exit wound or a significant splattering of blood. Regarding motive, prosecutors told the jury that the jealousy of Mrs. Russell, who was black, drove Robert, who was white, to shoot her behind the ear in the couple's quarters at Quantico Marine Corps Base and dispose of her body in a northeastern Pennsylvania coal mine. The defense argued that there was no proof Shirley was dead or that Robert had killed her. They said that the prosecution's case was solely based on circumstantial evidence and that Shirley Gibbs could still be alive. The defense produced witnesses who claimed they had seen Shirley with their own eyes after the murder was said to have taken place. One such witness was Corporal Daniel Carraway, who said he saw Shirley talking on the phone at the bachelor officer's quarters between 4 and 4:30 p.m. on the 4th of March. Another witness, a clerk at Rutter's convenience store, positively identified Shirley from photos and said she visited the store frequently to purchase lottery tickets. Caroline Baum, who lived on the base with her husband, said she saw Shirley walking along the road on the 6th of March. Quote, I had a very eerie feeling and I wanted to go back and pick her up. But by the time she had turned around, she saw the woman getting into a vehicle with a man who was not Robert Russell. The defense concluded their case by reiterating that this case was built wholly on circumstantial evidence. There was no direct evidence to indicate that Shirley Gibbs had even been killed in the first place. No hair or blood inside the vehicle, and no murder weapon was ever located. The jury was dismissed to deliberate, and on the 3rd of May 1991, they returned their verdict. They found Robert Russell guilty of the murder of his estranged wife, Shirley Gibbs. The verdict was so shocking, one newspaper reporter wrote that the courtroom was stunned into silence. For the first time in American history, a first-degree murder conviction had been handed down in federal court despite there being no body. Finelli could only say he was baffled as his client was taken away in handcuffs. It was said that some of the most compelling evidence was given by Pamela MacPhail, Robert's first wife, who had testified that during her marriage to Robert, when they were walking in the woods, he would say that there were bog holes at the bottom of mine shafts. Quote, "He told me that if he ever wanted to get rid of me, nobody would ever find me there." Another compelling piece of evidence was the computer document, which the defense had told the court was an outline for a murder mystery novel Robert and Shirley had been working on together. This clearly did not convince the jury. The verdict in this case was historic because there was no body, no definitive evidence to show that Shirley was dead. Prior to this case, many believed that from a legal standpoint, without a body, there could be no conviction. When this was put to lead prosecutor Lawrence Lyser, he played it down, saying it didn't really matter, it's not relevant. However, Robert's mother, Patricia Russell, disagreed with the prosecutor, saying, quote, "Do you realize this precedent, if it's allowed to stay on the books, means that if enough people say you did something, you will be found guilty in a court of law. This frightens me. I think the jury was intimidated by the FBI and the military presence." After Robert was convicted, but before he was sentenced, the prosecution received a postcard from someone purporting to be Shirley Gibbs. The postcard was mailed from the Netherlands on the 1st of July, 1991. Tests conducted on the postcard indicated that the fingerprints on the postcard belonged neither to Shirley nor to Robert, and that it was unlikely that the handwriting on the postcard belonged to Shirley. The postcard and the test results were disclosed to Robert in October 1991, shortly after the tests were completed, but after Robert had been sentenced. Prior to Robert's sentencing, there were pleas for leniency, which included dozens of letters vouching for the good character of the former Marine captain. At Robert's sentencing, Judge Kacharis said he followed federal guidelines in sentencing Robert, who was then 34 years old, for the murder of Shirley. Robert maintained his innocence before the judge, saying, quote, "I've always been a God-fearing person. I've never hurt a human being. I am innocent of this charge." He asked for leniency. He said the judge should recognize his opportunity for self-redemption and declined to impose the mandatory sentence of life in prison without the possibility of parole. The judge told Robert that even if he had the discretion to impose a lesser sentence, he wouldn't do it, and handed down a sentence of life without the possibility of parole. The judge did, however, grant Robert's request that he serve his sentence in a Pennsylvania prison, so he was close to his family. He was transferred from the Alexandria City lockup to the federal prison in Lewisburg. In May 1991, Fanelli presented new evidence to the 4th District Court of Appeals in Richmond, suggesting that Shirley Gibbs was in fact still alive. He relied on the postcard allegedly signed by Shirley as proof of this, along with Shirley's missing driving license and passport, which have never been located. Lead prosecutor Lawrence Lyser laughed at the absurdity of Fanelli's claim, saying, quote, "In the whole world of people, she chose to send a postcard to a special agent she hasn't met in her whole life." Fanelli also produced a statement from a woman who claimed she'd seen Shirley Gibbs jogging in Lansford shortly after the murder was supposed to have happened. In an appeal argued on the 4th of May 1992, Robert claimed that there was insufficient evidence to support his conviction. Robert claimed that much of the evidence introduced by the prosecution and admitted by the district court was irrelevant and, if not irrelevant, was so minimally relevant as to be more prejudicial than probative. In particular, he argued that the district court shouldn't have admitted testimony that he purchased a gun. They shouldn't have admitted a gun similar to the one that he purchased. They shouldn't have admitted ammunition used with that gun, and they shouldn't have admitted a tape recording of the test firings conducted at the Russells' former quarters. Robert argued that the gun evidence was irrelevant because there was no evidence Shirley was shot. There was no evidence a gun was fired in the Russells' quarters on the 4th of March 1989, and there was no evidence that a gun had any connection with her disappearance. Robert argued that the test firings were performed under conditions that were insufficiently similar to the conditions that existed on the 4th of March, and so were wrong. Robert argued that the district court shouldn't have admitted John Seasock's testimony regarding his conversation with Robert about the best method of committing suicide. They shouldn't have admitted expert testimony regarding the likelihood that a shot fired behind the ear at point-blank range would produce an exit wound or blood splatter. They also shouldn't have admitted Pamela's testimony regarding her ex-husband's familiarity with the mining regions of St. Clair, Pennsylvania. Robert explained that the admission of this evidence was improper because the prosecution's expert witnesses had no opportunity to perform an autopsy or other medical examination, as there was no body, and because there was no evidence he had transported Shirley's body to Pennsylvania. The Court of Appeal stated that relevant evidence is defined broadly as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. The gun evidence, the blood evidence, the evidence of how much noise the gun was likely to make, and the evidence of Robert's trip to Pennsylvania, all of which Robert contends was improperly admitted, was said to be unquestionably relevant to the prosecution's case. The evidence tended to prove that Robert had committed the crime and disposed of the body in the manner that the prosecution argued to the jury. The Court of Appeal stated that much of the evidence was directly responsive to one of Robert's chief lines of defence, namely that a shot inside of his quarters would have been heard by neighbours. All of the evidence was relevant in light of other evidence that was either undisputed or introduced without objection. For example, Robert admitted that there was a blood stain on the floor of the storage shed adjacent to Robert's married quarters at the time of Gibbs's disappearance, and that he removed the stain shortly thereafter. It was held that this evidence was not so prejudicial that it required exclusion. The Court of Appeal was not persuaded by the argument that the test firings were performed under conditions that were insufficiently similar to the conditions that existed on the 4th of March 1989. The test was admittedly conducted 4 hours later in the day than the actual shot was allegedly fired, and there was no evidence that the weather conditions on the day of the test firing were exactly the same as the weather conditions on the 4th of March. However, the test firings were conducted in the same location with the same type of weapon at approximately 4 p.m. on the 4th of March. The Court of Appeal stated that the significance of these differences was clearly a question of weight for the jury, not a question of admissibility for the court. Robert argued that the district court shouldn't have admitted testimony regarding the circumstances surrounding his discharge from the Marines and testimony regarding his extramarital affairs. The district court did not abuse its discretion in admitting the evidence, as evidence of other crimes, wrongs, or acts are admissible to prove motive, opportunity, intent, preparation, planning, knowledge, identity, or absence of mistake or accident. Evidence of prior bad acts are admissible unless it is introduced for the sole purpose of proving criminal disposition. Robert challenges 2 of the district court's jury instructions and its refusal to give 2 others. During the course of the trial, the jury foreman sent a note informing the court that the jury was unable to reach a unanimous verdict. The court recommended the jury be given the so-called Allen charge. When jurors cannot agree on a verdict and report this to the judge may issue further instructions to them to encourage those in the minority to reconsider their position. This is known as an Allen charge. Neither party objected in this case, and the charge was given. 3 hours later, the jury returned its guilty verdict. Robert claimed that this was an error. He argued the charge likely coerced the jury into returning a guilty verdict, and that a coerced verdict is particularly likely because the prosecution's case was so weak. The Court of Appeal determined that the fact the jury deliberated for approximately 3 hours after hearing the charge provides adequate assurance that the jury was not improperly coerced by the district court's instruction. At another point during the deliberations, the foreman sent a note to the court requesting a legal definition of reasonable doubt. The prosecution objected to the giving of the instruction. Robert, on the other hand, didn't object, but asked the court to give a supplemental instruction to the effect that the prosecution's burden of proof is strict and heavy. The court gave the instruction defining reasonable doubt, but did not give the requested supplemental instruction. Robert contends the court's instruction defining reasonable doubt was itself constitutionally defective. The Court of Appeal called his claim frivolous. Another frivolous claim, according to the Court of Appeal, was Robert's criticism following the court's refusal to give the jury an instruction on circumstantial evidence. It's well settled that as long as a proper reasonable doubt instruction is given, a jury doesn't need to be instructed that circumstantial evidence must be so strong as to exclude every reasonable hypothesis other than guilt. Robert asked the court to give the jury a corpus, I don't know if I'm pronouncing this right, I don't speak Latin, a corpus delicti. Delicti. I mean, I'm seeing deli, but that's not right. Delicti? Delisti. If you speak Latin, could you just let me know? That'd be fab. Because if this ever comes up again, I'm just going to look a fool again. Corpus, I'm just going to call it corpus deli. Screw it. Corpus deli are the facts and circumstances constituting a crime. Why they couldn't just say that, I have no idea. Why do you have to call it corpus deli? Delicti. Why'd you have to call it that? Just call it the facts and circumstances constituting a crime. But when the court refused to give this instruction, Robert constituted this as a reversible error. But shockingly, the Court of Appeal disagreed. Robert moved unsuccessfully for a judgment of acquittal at the conclusion of the prosecution's case in chief, and again at the conclusion of the trial. Robert claims the evidence against him was insufficient as a matter of law, and that the district court therefore made a mistake in failing to enter a judgment of acquittal. Robert accepted that the recovery of the victim's body is not necessary to prove murder beyond a reasonable doubt. Instead, he argued that when a body is not recovered, the corpus delicti, must be established by either confession, forensic evidence, bodily remains, discovery of the victim's possessions, or eyewitness or ear-witness testimony. I've never heard of ear-witness testimony. Of course it makes sense, but ear-witness, never heard of it before. The Court of Appeal held that the evidence in this case was substantial and more than sufficient to sustain Robert's conviction. They also stated that based upon the evidence, a rational trier of fact could easily have determined both that Shirley is no longer alive and that Robert was responsible for her death. In the case of Virgin Islands versus Harris, neither the victim's body nor a weapon was recovered, and there were no eyewitnesses to the crime. The murder conviction was affirmed, with the Third Circuit relying on evidence that was strikingly similar to the evidence in this case. Finally, the postcard. The Court of Appeal declined to address Robert's claim, noting that it was doubtful Robert was prejudiced by the prosecution's failure to disclose the postcard immediately, because it arrived after he was convicted. As long as evidence is disclosed before it is too late for the defendant to make effective use of it, there is no due process violation. Needless to say, Robert's appeal was rejected. The same court also rejected an appeal in 2014. The Third U.S. Circuit Court rejected Robert's 2016 appeal. In August 2018, District Judge John E. Jones not only rejected another appeal by Robert, who was then 58, but ordered the case closed permanently and refused to issue a certificate of appealability. Robert Russell is presently serving his life sentence at the Allenwood Federal Correctional Complex in Lycoming County. I'm sorry if I pronounced that wrong, people of Lycoming. And will most likely die inside its walls. He has filed 35 motions, petitions, and appeals related to his conviction, the most recent of which was dismissed on the 10th of May 2019. The lead prosecutor in the case, Lawrence Lyser, was reportedly suspended by the Justice Department in 1995 on charges of prosecutorial misconduct. It was alleged that during a high-profile 1993 trial of a cult deprogrammer named Galen Kelly, Lyser intentionally withheld evidence that the defendant could have used to prove his innocence. The charges are identical to the accusations made by Russell's attorneys in 1991. And that's the end of today's story. I found this such an interesting case. I'd love to know your thoughts. Should a conviction be allowed where there is no body, no forensic evidence, and no murder weapon recovered? Let me know by tweeting me at Student Verdict. Thank you so much for joining me for today's episode. The Student's Verdict is a bi-weekly podcast, so follow us on social media to hear about our next episode. The Student's Verdict can be found anywhere you listen to podcasts, including Spreaker, YouTube, and iHeartRadio. See you on the next one, and remember to keep living the dream.